They're not hunting pistols. The owner of these particular pistols carried 2 of them for self-defense. So what would happen if that same owner was to do it today? Well, while they're antiques, once you load them and start to carry them, they become firearms. They're more than 50 caliber, and all of a sudden you would find yourself in violation of the National Firearms Act, which happens to be a felony. The owner of these pistols strongly believed in the rights to own firearms, and ensconced that within the rights that we have in our Constitution today. If you want to see these guns, they're on display at the West Point Military Academy Museum, which I would highly recommend to everybody in this room. A tremendous presentation of the history of this nation. Okay. The owner, as you see here, perhaps not a surprise, was General George Washington. So what happens? We walk up to George Washington, hey George, good to meet you. By the way, welcome to 2017. By the way, you're under arrest. You've just committed a felony, and upon conviction, you can no longer own firearms for the rest of your life. I think it's difficult to believe this is what the Founding Fathers intended. So let's hop forward here. So let's come up from the 1700s and come over to 2011, now 6 years ago. Is Mr. Kaminsky in the room tonight? No? Okay. If I meet him at some point, I'd like to speak to him about some of these things. It was interesting, and he's in many ways has done us a service here. Joe Kaminsky was an individual here in Connecticut. He held a federal firearms license. He had a state permit to sell pistols and revolvers at retail. He obviously had a pistol permit. One evening, there's a knock at his door. An officer who he knows shows up and says, I need to seize your firearms, because in 1964, you were convicted of a felony. The officer has no warrant. He just shows up at the door, and Mr. Kaminsky, being a good citizen, knowing the officer, kind of opens the door, steps aside. Let's talk about this a little bit, just because this would go on to be a problem for Mr. Kaminsky within his litigation. And should this happen to anybody here? If an officer comes to your home and wants to come in, and he does not have a warrant, you have no duty to let him or her in. You should not forcibly object to that officer entering. But once you say, I object to your coming in, you have now established your Fourth Amendment rights. When it gets down to court, we can then have suppression of evidence. We have protections in it. There was debate within the various legal proceedings as to whether Mr. Kaminsky had agreed to this or he had not. The judge found that he had consented. So for everybody in this room, just put in the back of your mind there, we all know officers. We're all friendly with officers in our town. This is a thin blue line group we have here. But when they don't have a warrant, you have to say, I'm sorry, you can't come in without a warrant. If they do, and we'll deal with it later. Okay. So once again, coming over here to the issue of consent and the prejudice is what we have there. So just a note, something probably everybody in this room already kind of intuitively understands, but for Mr. Kaminsky, this became a problem. Okay. Here's question number 2. The officer has come to his house. He says, Mr. Kaminsky, you're a convicted felon. Mr. Kaminsky had an FFL. How could an FFL, how could you have an FFL if you have a felony? And the answer to that is it is not clear whether or not he was, in fact, a felon. He had pled to something in 1964 having to do with fraud. We've had a couple of these cases lately. There are crimes that back in the 50s and the 60s were not well defined as being either a misdemeanor or a felony. In many cases, those laws are long gone. It's hard to find the histories on them. The records on them, in many cases, are gone. We just had another one where an individual in 1957, while he was a member of the Air Force, was charged with possession of a machine gun. He said, I'm in the Air Force. It's my duty weapon. I'm authorized to have this in the vehicle. The commanding officer comes down to the base. He says, what are you doing? Let my man go. Give me my machine gun. The judge says, that'll be $5. Commanding officer pays the $5, stomps out of the courtroom. It shows up on a NICS check as the fact that he pled guilty to possession of a machine gun. Now, an active duty member with his duty weapon could commit that crime is foolish, but that's what's in there. We've been told if you want to get it off NICS, you have to prove that he didn't plead to a felony. The court's been gone for 40 years. There are no records. All that we have is something in a computer someplace. Very hard to refute. Mr. Kaminsky, something in 1964, we don't know what it is, but it's not relevant to this case because, if nothing else, in 2013, Mr. Kaminsky was granted a full pardon. The state in the Kaminsky litigation says there is no dispute that we gave him his pistol permit back. No one's claiming he's a felon. He can go buy as many guns as he wants. We're just not going to give back 3 of the guns that we took, and we're going to discuss why here. Okay. When we look at why this is in court in 2017. Remember, the officers go there in 2011. So why do we have a 2017 case here? What's going on is this. Okay. The firearms that they're holding are either machine guns, 2 cases, or in 1 case, what they're claiming is an AK-47 type. The state police came in and said under the original 93 law, as carried forward, these are Section A specified firearms, and they had to be registered back in 94. 93 Act, effective in 94. Mr. Kaminsky comes back and he says, no, that's not right. He says, number 1, these are machine guns. I've got a Form 4 from the ATF, and every year I register this gun on what's called a 202 card. Many of you may know the little index card you file every year. Number 2, he comes in and he says, these are not within the category of assault weapons. These are machine guns. The state's position has long been, and continues to be, that if a machine gun is select fire, that is to say that it can fire both full auto and semi-auto, that select fire feature is there, it comes within the assault weapons ban, and it has to be registered both as a machine gun and as an assault weapon. So while the state came in and said you legally bought these machine guns prior to 1994, and you have fired all of the forms, the 202s, every year, you didn't file it as an assault weapon. We see this case frequently. In some cases, we've been able to fix that problem. If anybody has that problem, talk to me separately. We can go through that. The court, however, they're asked, firearms from prior to 1994, October 13, 1994, can they be an assault weapon, or are they automatically a pre-ban? Probably what most of the people in this room would expect. All right, so once again here, can a machine gun be an assault weapon? That is the state police position. If you have, I'll just give you a quick example here. If you have an M16 and the disconnector is out, it can only fire full auto. When you pull the trigger, it fires. When you let go of the trigger, it stops firing. With that disconnector in, it can also fire semi-auto. So if that M16 does not have a disconnector and you've got a Form 4, it does not need to be registered as an assault weapon. This is absolutely clear. Kaminsky doesn't change that. You put that disconnector in there, now at least under their position you have a problem. Now let's talk about the Bradford letter. It's been on the blog here at CCDL for some time. The court discusses the Bradford letter, and counsel for Mr. Kaminsky comes in And he says, the state police concede that if it's before October 13, 1994, it's not an assault weapon. It's pre-ban. That's their position. Now what happened here is we have a new commissioner. And the new commissioner has taken a different position. So she goes into court and she's arguing against the position of her own department. Okay. What happens next is the court comes in and says, I agree with the new commissioner. I do not believe, the court finds, that if a firearm was produced prior to October 13 in 1994, but is one of the 56 specified firearms, it is not a pre-ban. Now, thousands of these have been sold across the state. Probably half the people in this room own one. We've all relied upon the state police, and the judge comes in and says, I am not bound by the administrative action of the state police. As a matter of law, I find if you have one of those 56 guns, including various listed by type, it doesn't matter when they were made, they're not pre-banned. Now, what are they going to do about this? We're going to start to talk about it, and there's some opportunities here. Okay. When we look at this historically and where this comes out, some may have been on my talk on this 2013 law that I gave back in 2014. At the time, we had some discussion of the fact that this law continues to be so ambiguous that no one has a clue what it means until we got clarification from the state police. Okay. But the Office of Legislative Research, which is not an enforcement body, they have no power to make rules. They simply exist as part of the legislature to try and help legislators to interpret laws. They analyzed the law in 2014, and they said exactly what the court says in Kaminsky. And while the court doesn't say it reading the case, I think we have to assume that they have simply adopted the part of the position coming right out of the Office of Legislative Research. Here's a copy. You'll see them if you go online and you search Office of Legislative Research Report. It's 2030 R0241. Anybody who needs any of this, I think CCDL is going to have some of this available, or you can contact my office and I can provide these things to you. And here's part of what was within that OLR report. And it goes down and it talks about the laws going back from 13-3, the original, back to the 1993 law, and then 13-3 later on, and says basically the law has evolved, it has continuously expanded what's included, but those original 56 which were banned never were unbanned. Okay, so that's what OLR says. Okay, now the state police, Special Weapons and Licensing Unit over there. Special Firearms Licensing Unit, should say. My office spoke to them. Most of the council in this room probably spoke to them. I think probably every dealer in the state spoke with them. I don't know anybody who has ever told anything other than that if it was prior to October 13 of 1994, it was pre-banned. So here's the conflict. We've got two people. We've got the body which regulatorily interprets this law, and we have the Office of Legislative Research, and they don't agree. Okay. The court with Kaminsky has now come in, and they've said, okay, we're going to decide the issue, and we're going to decide that the state police were wrong, OLR was right, and if it comes within those 56 guns, whenever it was made, it's contraband. That means it's illegal to sell, it's illegal to own. Big problem. Okay. Now, of course, for everybody in this room, what's the first thing you're going to say? I got a DPS-3 right here. It's got an authorization number on it. We told the state police exactly what it was, and knowing what it was, they approved it. Now, what happens when you walk into a courtroom and you say, this man's got an illegal gun, he bought this contraband? And you step up and say, yeah, state police said it was fine. Now, state police does not actually approve sales, but they do issue these numbers. The key part is they certainly were on notice. They certainly knew it. They certainly at no point have indicated that there was anything incorrect about these. Given that, what do, as we stand here tonight, and this probably impacts a lot of you, do I think the police are about to go out and start arresting people? I would hope not. It would be nearly impossible in a courtroom to proceed with such a case where a person has lawfully purchased it through a process of a dealer and an authorization number. So I would certainly hope that something that absurd would never happen. Now, here's the really important part. If there's one thing that you walk away with tonight, it's called facial vagueness. This is part of due process, the Fourth Amendment. And what I want you to do, I want everyone in this room to take a look at the language which is up here on the screen. This particular language comes from an authority some people may recognize. It's called the United States Supreme Court. And it was specifically cited by Benjamin, the Connecticut Supreme Court, in the original assault weapons case. A statute which either forbids or requires the doing of an act in terms so vague that persons of common intelligence must necessarily guess at its meaning and differ as to its application violates the first essential of due process of law. What this says is that any criminal law which is written so poorly that a person of common intelligence must guess at what it means is unconstitutional. So where does that lead? Well, I guess then we have to ask, who is a person of common intelligence? I am quite certain there's a number of members of the legislature, after 32 years of my speaking on these issues, would challenge my common intelligence. But I think they're going to be hard-pressed to challenge whether or not the Connecticut State Police are of common intelligence. When we brought the first challenge, this is in the days before CCDL. This is back in the days of Coalition of Connecticut Sportsmen. The NRA get together here. The case is brought. Wes Horton, the prominent constitutional scholar, myself, my former partner, Mark Benenson, rest in peace. We had a great team of counsel in here. We got together and we sat down, and the first questions we asked ourselves is, do we know what this thing means? We read the statute. We had 7 or 8 attorneys in the room, people who have got decades working on this. One of them was former general counsel at Colt. He also has a degree from a gunsmithing school and is certified as a trademark examiner. And we sat there, we looked at him, and it's like, you have any guess what this means? Nope, not a clue. I don't know what it means. Went all the way around. Not one of us could interpret it. From that, we can argue whether or not lawyers have common intelligence. But from that we concluded this thing was so vague, there was no way to interpret it. So, why did we lose the case? We tried it for Judge Dranginis up in Litchfield. We took it to the Connecticut Supreme Court. We lose twice. What happened was this. I put a year of my life into this. The trial court came in and asked one of the dealers, do you know what an assault weapon is? And the dealer replied, if you ask me what is an assault rifle, yes, an assault rifle is a machine gun used by the military. But if you ask me what an assault weapon is, no. Well, somehow in the notes, it just didn't make it through. And the judge finds that because the dealers know what an assault weapon is, it would not be unreasonable to ask any of you, if you want to go buy one of these firearms, to go ask your dealer whether or not it's on the list. I think what this said was, the court's not sure what it means, but we think the dealers know what it means, so you can go ask the dealer. Now, this is a lot like asking a fox whether or not it's okay to eat the chicken. And to suggest that in a criminal prosecution, the person would come back and say, my dealer said it was okay, this was ridiculous. When I got up to the high court, they didn't try to argue that part of the decision up there, but they tried to come up with something else. And the court looks at it, and the court says, well, listen, we recognize that there are identical guns, that they are absolutely in all respects identical, except for the markings on the receiver. And that one of them is a felony, and the other one's perfectly legal. But the court says, because this is a civil challenge, we're going to defer to the legislature as to why they did that. The legislatures can decide what things to ban and what things to not, as long as they have some reason for it. And the court found that whatever reasons they were saying was satisfactory to the court. But the important part was this. The court found that it was clear what guns were prohibited, what guns were included by this list of 56 weapons. And one of the things they said was, well, if you're unsure which guns it is, you could go look at the manufacturer's catalog. If any of you happen to have a catalog, for guns made, in like 1940, maybe you could share it with the rest of it. This was absurd. But it was this result which wasn't workable, but there was no place to appeal it to. Justice Learned Hand of the highest court in New York once famously said, "We are not the highest court because we are always right. We are always right because we are the highest court." They were the high court. And once they reached that decision, it left us with a stalemate. And for 23 years, we've sat here and waited for a point where we could go back to the court and say, oops, maybe it's not so clear. So it's not an easy thing to go back in, but what has just happened with SLFU, with the State Police Licensing Unit? We now have a case where the court has found that the state police don't understand the law. Well, if the state police don't understand the law, then I would argue that as they are deemed to be of common intelligence or more, that it's void for vagueness. That is to say, it is unconstitutional. So where are we now? Let's start with things that Kaminsky does not debate, things which are now absolutely clear. Let's assume that you have an essential arms firearm, EA-15, fairly common out there, manufactured prior to October 13th of 1994. It's fine. Guns that are not on that original list of 56, they're clear. So for anybody who owns something prior to the date which is not on the list, nobody at the moment is saying anything to suggest that those pre-bans are not absolutely fine. What guns are not okay? Any gun that is on that list of 56. So when we look at the Kaminsky case, what the court didn't go into the vagueness issue. I'm not sure it was even raised. I'm not sure why. It was not my case. But what the court found is that the firearms involved in the Kaminsky case, an Uzi machine gun, Mac 11 machine gun, and what they refer to as an AK-47 type, I haven't seen any of them. But what the court finds is, whatever the law means, it's absolutely clear that these three guns are among the 56 specified. And therefore, we will not return them because they're contraband. Remember this 2017 case, this is all about whether or not they would return his guns. This is not a criminal action. This is an action to try and get the firearms returned. Okay. So what's going to happen now? Okay. Well, in 1994, when we went before the court and up to Connecticut Supreme Court, we said that we don't understand. 23 years later, we're still arguing about it. We still don't know. Perhaps it's time to figure it out. But I wrote to the licensing unit last week. Some people here may know Detective Ken Dillon. I've never had a problem with Detective Dillon. He's always been straight up with me. And he wrote back to me and he said, I can't answer your question, Greg. He says it's gone up to the legal department, and when the legal department decides what the Kaminsky case means to all of this, we will let you know. I'm waiting. So we haven't heard anything more. Part of the reason I mention this, I've had probably close to a dozen calls and emails from people explaining to me what the Kaminsky case means. These are largely based upon supposedly conversations that they've had with police officers. What basis these police officers had, I don't know. Some of them allegedly came right from within the license unit. They may have been early attempts to try and interpret this, but Detective Dillon's words as of a few days ago is we don't have a position. So for everybody who's out there who says, listen, I spoke to them 2 weeks ago, here's what they told me. Unfortunately, I don't think we have anything we can rely on right now. This is just the heading back from our days of Benjamin versus Bailey. And decided July 25th, 1995. Here I stand before you in July of 2017 on exactly the same issues. This is the Kaminsky case. We have copies for anybody who would like to sit there and read through it. Obviously, I have tremendously simplified these proceedings. The Kaminsky case was litigated in both the state and federal courts. There were a number of other decisions that have occurred out there in the background. I've tried to condense this down so we could get it into a relatively short period of time and get the key concepts to you. So we're specific questions. You're still going to have to speak to your counsel, call my office, something of that sort. We can try and get you to work through it. Advice that we have for you right now. Number one, know what you have. If you have not inventoried your guns in 40 years, sit down, make yourself up, take out a piece of paper, write it down. If you know where you bought it, write down where you bought it, when you bought it. We don't know what's going to happen next, but as this starts to evolve, it may take you some time to find and make these records. Start to do your homework now. If you have guns that give you a lot of concern, once again, good time for a call out to counsel. In many cases, if I can get in before the state police get in, or whoever your local counsel is, if they can get in many cases, if we do it beforehand, we can come up with something to resolve a problem. Once someone's at your door, they've taken it out, they're standing there, it's much more difficult to do it after the fact. So start early. Thank you very much to everybody. I wish we had more.